So now let's consider the Napster case, and we could say that the Napster case involves an early peer-to-peer network, and the legal analysis that I initially want to focus on is the analysis about fair use. But as we get into the case, let me talk for a moment about the kind of network that Napster represented. So let's consider first a typical client-server network. So you will have a computer that functions as a server, and you will have multiple client or peer computers. So let's say that this computer wants to communicate with this computer on a typical client-server model. It's not going to communicate directly, but that communication is going to go first to the server. The server is then going to route that communication to the other peer. You might have on many typical client-server networks, you might have some storage of files on the server. You might have the server connected to hard drives with storage. The local peers might have some storage. So, this computer wants a file off of this computer. Again, it will go through the server and get routed, and the file will get routed through the server. This computer might want a file that's in storage, and then this computer might be able to share that file as well. That's a more typical kind of client-server model. You might have multiple servers, and perhaps even multiple smaller parts of the network kind of networked together. That's a typical model. So then let's look at a peer-to-peer network. And in a peer-to-peer network, a pure peer-to-peer network, all you would have is individual peer computers. You would have no centralized server. And these peers, if they want something from each other, they want to talk to each other, connect directly to each other. This computer wants a file from this computer, there's a connection directly between them. Similarly here, and we can have direct connections between and among all of these computers. There is no centralized hub, no centralized server. Now when we think about the Napster network, Napster was really a sort of a hybrid peer-to-peer system. You did have the individual peer computers, the individual users who want to find, say a copy of Springsteen's Born to Run. But there was a centralized Napster server. And so the first thing you would do, if you wanted to find that copy of Born to Run, was connect to the Napster server. Now the Napster server didn't have music files, it had text files. And those text files contained information about other peers that are connected to the network and what music files they had available locally. So let's say this computer had Born to Run on it, an MP3 file. This computer wants it. It connects to the Napster server. The Napster server communicates back the text information saying, here's the IP address where you can get Born to Run, and then the connection is directly established and the MP3 file is transferred. So Napster server doesn't have the music file, but it does have information about the music file, and it is, at least according to some of the evidence in the case, capable of it is, at least according to some of the evidence in the case, capable of seeing what is in that text file and potentially even of blocking certain information from the text file. In other words, it has a certain degree of knowledge and a certain degree of control of what files are available for sharing between peers across the network. So on the question of fair use, then the court looks at the purpose and character of the use factor and says there's nothing transformative, the file doesn't change, and further that the use is a commercial use. Now, note this citation to the Campbell case. This is an interesting citation. Campbell was a case involving Two Live Crew rappers who did a parody of the older rock song Pretty Woman. And the fact that the parody made money and was for a commercial purpose didn't necessarily cut against fair use, but it was a factor the court looked at. Now, with a parody, you're doing it for money, but the work is highly transformative because it's changing the underlying nature of the work. That wasn't the case here. Nothing changed, just commercial. As to the nature of the underlying work, it's a creative work. As to the portion used, the whole work was used. Then very interestingly, as to the effect on the market, and the effect on the market factor, as I was saying before, how this relates to the way the majority and the dissent in the Sony case were looking at the effect on the market. The Ninth Circuit here says Napster hurts the market in at least two ways. One is, and you have to put yourself back in the time that the Napster case was decided, where there was not yet a robust iTunes or other, dollar or $1.50 a song download market. Basically, you wanted a song, you had to buy the whole CD. And so the court said it hurts CD sales because people are downloading the songs they want or downloading all of the songs from the CD and not buying the CD. But also that there's a potential future market for the individual song downloads. Even though that market doesn't exist yet, the court said that's kind of within that scope of what the copyright holder ought to be able to control. And that's a bit different than the majority was saying. It's actually, I think, more consistent than with the dissent in Sony. So kind of an interesting move. All right, then on this question of secondary liability, the court says this is not like the Sony case. And this is where you have to tie in the way the Napster network functioned. So because that information resided on Napster's central server about who was having which songs accessible and which songs were accessible across its network, and because they had, at least according to some of the evidence, an ability to filter that, Napster then was considered to be encouraging and assisting the infringing conduct. And further, Napster had an ability to control and to supervise, at least to the extent that it had control over that text file. That then leads us to the Grokster case. And now here in the Grokster case, we're really dealing with a next generation kind of peer-to-peer network from the Napster network. So we'll take a moment now and look at the way the Grokster network functioned. So now let's consider Grokster. Now I think when you look at the music industry's litigation against peer-to-peer file sharing services, you'll see that the technology changes, and in certain respects the technology changes in order to sort of keep ahead of the lawsuits. I actually think the lawsuits in some ways pushed the technology. I think the technology was otherwise changing anyway, but some of it was the lawsuits. Some of it was the fact that broadband was becoming more available and more widely used, although not everybody had sort of the same ability to have a broadband connection. So under the Grokster system, you've got some peers that have more bandwidth, and those are designated as super nodes, and then others are just ordinary nodes. So the information about the files on the network is distributed across these super nodes. There is no one central location that contains either textual information or music files. And there's no central server controlled by Grokster that has that kind of information on it. So if this computer wants a copy of Born to Run, it may connect to this super node. That super node may tell it that it can connect to this computer and get that file if it wants it. So this is much more like a true peer-to-peer network, although there are these super nodes that are functioning somewhat like servers, but they aren't centralized servers. It's much more broadly distributed. So this is going to become important in the Grokster case because in Napster, where you have that at least central place where there is information about the files kept, it's a bit easier to say that there's some kind of contributory copyright liability. In Grokster, you can't say that Grokster controls that technological capacity. And that's why the Grokster court really focuses on inducement and the advertising Grokster does in distributing the software platform that it does distribute. So then the Grokster case gets to the Supreme Court. We've looked at the nature of the network. Grokster also kind of aggressively advertises itself after the Napster Network ultimately shut down, as a direct result of the litigation against Napster. Grokster advertises itself as we're the new Napster. You want what Napster had, you can come to us and get it, and advertise itself as being the place to go to download music. Grokster made no effort to filter any infringing material, whether it had any technological ability to do so or not. And its revenue model was really driven by advertising space on its site and through its software. So it made money the more connections there were. Now the Ninth Circuit had said that contrary to the Napster case, Grokster could not be vicariously liable because Grokster did not monitor or control user activity and had no independent duty to police user conduct. It's just selling technology. And the majority of the Supreme Court disagreed. So Justice Souter wrote the opinion. Souter notes that there is either direct or inducing or vicarious liability. Now the Ninth Circuit had focused heavily on, as you would expect, on the Sony decision. But Souter says, well, Sony doesn't say that any time a technology is capable of substantial lawful use, it's okay. Sony is really about the design of a product. Is the design of the product designed only for infringement? But beyond that, Souter says, there are other things that we can look at to decide whether there is contributory or secondary liability, and that includes whether there's an intent to induce infringement through advertising, not just through product design. And ultimately, Souter said there's clear evidence of that intent in this case. Indeed, he said that perhaps Grokster could have adopted some kind of filtering technology and could have certainly tailored its advertising in a different way, but didn't do so. Now, there are a number of other opinions in the case. We have an interesting contrast between Ginsburg and Breyer. You will actually often see in Supreme Court copyright law jurisprudence contrasting opinions between Ginsburg and Breyer. Often one or the other is in the majority and one or the other is in the dissent. But here, they both agree with the result, but Ginsburg says, look, the Grokster software is not even capable of a substantial non-infringing use. The only real use that it's used for is to infringe. Breyer wants to push back against that and say, no, actually there are quite a bit of possibility for non-infringing use. We don't want to get into regulating a technology. And indeed, Breyer thought that at the time that this kind of peer-to-peer software would become a bit of the wave of the future and was worried about copyright sort of closing that up. But he says here there is clear evidence of active inducement through the advertising, so that's all we have to get at. Now, interestingly, Breyer was sort of wrong about the technological future. I mean, peer-to-peer, I think it's fair to say, is still mostly used for sharing infringing copies of music and movies, and then also for pornography, including for contraband child pornography. And if you want to share files in a non-infringing way, for example, like I'm sharing edited copies of case law with you in this class, how do we do it? We use the cloud. So we'll use Google Drive or Dropbox or something like that. which is not peer-to-peer. It's, the file is stored on a server that Google or Dropbox or whomever controls. It's just that technology has grown, and there are fights in copyright and secondary liability dealing with those kinds of services as well.